I call the member for Deakin.
Thanks, Mr Acting Deputy Speaker. Look, I just wanted to briefly speak in relation to this bill. Look, I want to congratulate the Treasurer, Joe Hockey, in so quickly coming towards the aid of Australian financial institutions in concluding the FATCA Agreement. Basically, the problem is for Australian financial institutions based on this unilateral decision made by the United States government, is that Australian financial institutions with any presence in the United States could be subject to a withholding tax rate of 30%. The Treasurer, in announcing the signing of the agreement, highlighted the importance of this change in reducing the burden on Australian financial institutions and, in particular, the due diligence that would be required from Australian institutions in effect managing each of the accounts that may or may not be relevant to the FATCA requirements. Basically, in order to comply with the relevant reporting obligations, Australian financial institutions would have been required to undertake a range of procedures in identifying all relevant accounts. Broadly, FATCA requires foreign financial institutions, in this case Australian institutions, to provide the US IRS with information on US citizens living abroad who have more than $50,000 in their accounts. So it is a very wide-ranging and significant compliance burden on Australian financial institutions. The commencement of the regime is looming on 1 July 2014, as the member for Fraser said, and it will obviously have a huge impact on Australian financial institutions at that time. The problem here, and one of the reasons why we've had to enter into the agreement with the United States, which is now the subject of this bill, is that Australian privacy laws generally prevent compliance with these US-based regulations, and there are some Australian state and territory anti-discrimination laws that could also prevent the interrogation of customer accounts based on US citizenship. So, in recognition of the fact that many of these domestic laws would otherwise prevent foreign financial institutions from fully complying with FATCA, the US developed an intergovernmental agreement approach to manage the legal impediments, simplify practical implementation and reduce compliance costs for relevant financial institutions. And that's why I want to congratulate the Treasurer, Joe Hockey, for moving so quickly to sign the intergovernmental agreement with the United States in April. As always, this government has its eye on the ball when it comes to making sure that our businesses aren't weighed down in red tape and unnecessary administrative costs. Unfortunately, that wasn't the case when those opposite were in government. Treasurer Joe Hockey was advised soon after last year's election that 96 tax and superannuation announcements, with one dating back to as far as March 2001, had not been legislated. One of those announcements related to FATCA. The former Treasurer announced his intention to negotiate an intergovernmental agreement with the US in November 2012, but it wasn't signed by the former government up until the election. This slack approach wasn't fair on Australian businesses or consumers, and it created uncertainty, particularly with the possible likelihood of withholding tax applying to Australian financial institutions. But that approach has changed, and we've ended the uncertainty with the subject of this bill. And we're listening to businesses and consumers. Importantly, the Australian Bankers Association welcomed the signing of the intergovernmental agreement. Steve Munchenberg, the Chief Executive of the ABA, said, "We congratulate the Australian government in securing this agreement. It will enable Australian investors and savers to more easily access the US economy without suffering a prohibitive 30% withholding tax cost. This is an essential development in facilitating capital flows into and out of Australia while having best practice regulation." And he finally said the current and previous government's work in this area will ensure Australia continues to have one of the world's most competitive financial sectors, a major factor in economic growth. So again, I want to congratulate the Treasurer in ensuring that the uncertainty that applied with the possible application of withholding tax in the United States is not an issue that Australian financial institutions have to worry about any further. There are, of course, compliance costs associated with this measure. As a government, we're proud that the approach we've adopted ensures that the compliance costs are really the lowest of all of the available options. And again, it's to ensure that capital flows in and out of Australia can be as free as possible and not subject to interest withholding tax. So I'd just like to again congratulate the Treasurer.